Hello again. This is the last video by Professor Monica Chow. This class is on procurement as well. In the last class, the last video, I talked about the principles of procurement law, I talked about the legislation, the European legislation, and now in this class we'll go into how does a tender procedure actually takes place. What are the details you should know something about? So first of all, we have to make a choice which procedure do we choose, because there are different procedures that you can follow as an contracting agency. You can choose for the open procedure. In an open procedure, everybody can say, I would like to do this job, these are my qualifications, and I'm going to do the job for so much money. That means that a lot of people will react to the call for tender, and those people will give information on themselves and on the job to be done, so their offer. You always have to distinguish between the information you have to give on the person who's going to do the job, and the offer that a person makes. So in the open procedure, a lot of people can apply to take part in the procedure, and everybody will be there, and everybody has to say something about himself, his business, and about the offer they come with. That means that it is costly for a lot of people, because it costs a lot of money to enter a procurement procedure, and it is also costly for the government agency, for the contracting agency, because the contracting agency has to look at all this information it gets. So it is democratic, you might say, because everybody can join, but it's also very expensive. So the second procedure solves this problem somewhat. The second procedure is called the restricted procedure. And what happens in this procedure is the following. In the first phase, everybody can say, I'm interested in a certain job, and I am this business, these are my qualifications, and everybody says that. All those people who apply will give that information to the contracting agency. Then the contracting agency makes a choice out of that, let's say 100 people, and it makes a choice of 5 people, and those 5 people will be asked to come with a price, with an offer for how they're going to do the job and for how much money they're going to do the job. So we have a cut in the first phase. Everybody can come, say something about themselves, qualifications, money situation, technical situation, etc. But on information on the person to do the job, on the business to do the job. And secondly, they will give only a few will go through to the second phase and give information on the offer. That makes it a lot easier, less administrative costs for both parties. Then we have the competitive procedure with negotiation and the competitive dialogue. These are procedures that also know such a cut, but these procedures make it possible to talk by the employer to the people coming with the offer. So these, with the first 2 procedures, that is practically impossible. When you talk to people, you will have to talk with everybody. Everything you communicate in the first 2 procedures will have to be shared with all the people who enter into a procedure. With the competitive procedure and the competitive dialogue, that is not the case. That is a principally different procedure. Innovation partnership is a new procedure. I will leave that for what it is. And a negotiated procedure without prior publication, I will also leave that for what it is. The most used procedure is the restricted procedure. And the very interesting procedures from the viewpoint of the way you want to talk to one another. Because when you have a complicated assignment it is very normal to discuss the assignment. How should you do it? What kind of trouble do you expect? What are the complications? It's normal when you go and buy, for example, a car. You go and have a look at the shop. You come back. You talk about this. You talk about that. That is forbidden in the open and in the restricted procedure. But the other procedures you cannot very freely use. The competitive dialogue is easier to be used nowadays than in the old days, but still not all the time. So you choose one of these procedures, and I will assuming in the next sheets that we are talking about a restricted procedure. So first you think, I have a job that's a little bit complicated, not very complicated, so the competitive procedure or the competitive dialogue is over the top for me. But the open procedure would be too gross, would lead to too much administrative work. I just would like an offer from a few people, so I will go for the restricted procedure. In the following sheets you see these details that I've just described. I will go through this just like that. Again, this information in the sheets is of importance during the test. So you made your choice. Now, how does the procurement within that procedure you've chosen take place? And like I said before, we have a strict separation between choosing the provider and choosing the offer. In principle, you first choose the provider on the basis of certain criteria that I will show in a second. Then, when you have certain providers who meet the criteria, from those providers you will look at their offer. And with the restricted procedure, first you choose 4 or 5 or more possible providers. Those 5 providers will come with the offer, and the offer you will choose in a specific way as well, again according to certain criteria. So how do you choose the provider? First of all, certain providers you do not want. Sometimes you have to exclude them, sometimes you want to exclude them. So the procurement law has grounds for exclusion. And grounds for exclusion are, for example, membership of criminal organization. If somebody is a member of a criminal organization, then you are required to exclude that person. If somebody has been convicted of bribery or fraudulent behavior or money laundering, there is no more choice. You have to exclude those people. So they will not be allowed to join the tender. You also have the possibility to exclude providers when they're bankrupt, when there's been a conviction for misconduct or a professional fault, they didn't pay the taxes or they made false statements. If a provider does not find this all that important or thinks maybe that does not really occur, he is not obliged to use these exclusion grounds. You can choose to do so. But if you choose as a contracting agency to use these criteria, you say in advance, I will exclude the criminals, but I will also exclude, for example, people who have made a very big mistake in the past or who have been convicted for not paying their taxes. Then you will have to use that criterion. So again, you look at these people, and there are some people who indeed have made professional faults and have been convicted for that or made false statements. Out they go. They are not allowed to go on. These providers you exclude. But there's more. You also want to exclude people who don't meet your standards. And you have minimum standards. You have certain minimum standards that you say everybody who would like to potentially get this job has to have, for example, certain diplomas of a certain level. So we have minimum standards, and with the restricted procedure we have minimum standards, and besides that we have selection criteria that we use to choose from that big group of providers who meet the minimum standards. Then we say everybody who meets the minimum standards, I'm going to make a second look, take a second look at those people, and now on the basis of the selection criteria. And these criteria, both the minimum standards and the selection criteria, they must be objective and proportional. Again, for the equality I talked about in the first video on procurement law. And once you published these selection criteria and minimum standards, you cannot change them anymore. So once they're published, you cannot think anymore, by using this standard I cannot use this famous architect anymore because he had a conviction of a mistake, for example, a professional fault in the past. So the standards must be objective and proportional, and they must be published, and once published they cannot be changed anymore. Now, what are your minimum standards and your selection criteria about? They are about the economic and financial standing, because you do not want a provider who is financially insecure or who is economically completely dependent upon the job you are going to give. Because if he has a setback economically or financially, then he might go bankrupt. And if he goes bankrupt, he might not be able to do the job for you anymore. So you want somebody who is economically and financially solid. There are ways to formulate that. So you formulate these rules, again, transparent, objective and proportional. Also, you want somebody who can do the job from a technical point of view and who has enough people to do the job for you. So when you have a complicated job, then somebody who graduated yesterday from a technical university does not meet the technical ability that you need for this job. So that person will not be allowed to come with an offer. You have to exclude him because he does not meet your technical capacity or technical ability. How can he get that technical ability? By joining together with someone else. That's how you can gain enough experience and gain enough ability, so later on, maybe on your own or still together with some other people, you can pass the technical standards. What can play a role is past performance. You might ask for information on past jobs that have been done, as long as it's objective and transparent. So now we have chosen a provider, and now they have to come with an offer. And the offer is for how much money are they going to do the job. But there is actually a lot more than that, because we have to choose the most economically advantageous tender. And the most economically advantageous tender, from the point of view of the contracting authority, shall be identified on the basis of the price or cost, using a cost-effectiveness approach, such as life cycle costing, in accordance with Article 68 of the Directive, and may include the best price-quality ratio, which be assessed on the basis of criteria including qualitative, environmental and/or social aspects linked to the subject matter of the public contract in question. A long sentence. What it means is, as a contracting agency, you need a faculty building. And you want that faculty building to have a certain quality. And you also have a certain price in mind. And you would like to have a life cycle costing approach. So, for example, what you do is this. You say, I have 100, the best provider can earn 100 points. I find the price not very important. I find the quality that I get more important. So the person with the lowest price, for example, will get 40 points. Then I have 60 points to divide over the quality. And then you can say, I find circular building very important. I find environmental aspects or social aspects very important. Or maybe the aesthetic way the building looks I find important. Because you might have something subjective in there, as long as you judge it in a proper way. So you had these 100 points, 40 points for the price, and then you have 60 points to still divide over these other sub-criteria that you have. So you might say 10 points for the best aesthetical design, 20 points for this, 20 points for that. So that's how you fill up the 100 points, for example. So if you have 100 points to divide, you can make that system up yourself, how you can do that. There's a lot of information to be found how you can do that. But imagine you choose for that 100-point approach. And you say, I find the price the most important thing, and I give that 90 points. Then you have no demands on which you find very important in your award criteria for quality. So basically, you have chosen the lowest price as the award criteria. And that is actually not allowed anymore. You have to choose for the economically most advantageous tender, and that means there has to be a division between the price and the quality. And if quality gets so few points that actually doesn't play a role, then you're not doing it properly. So once again, you choose the provider on the basis of the exclusion criteria, on the basis of the minimum criteria, the selection criteria, technical quality, that is financial, economical standing, have you been convicted, yes or no, and then from those people that meet your selection criteria, you have a few that make it to the second phase, and the second phase is the award phase, and there they will come with an offer, and the offer will consist of information on the quality, the way they're going to do the job and what the quality is of that, and the price for which they're going to do it. So this is in a nutshell what you have to know about procurement law, and more of it is written in the book, and keep an eye on these sheets because they are important as well. You find a few more sheets on the information. You can see them now. I just go through them. They're very important, but read about it in the book as well. After the award, you have a period of at least 10 days. Actually, it's 20 days. It's 20 days now. So you have a winner. Somebody came with the best offer. Can you give him the job now? Because you have not entered into a contract yet. All you know now is that he had the best offer. Now you have to wait before you enter into the contract, because maybe some people do not like how you have come to this decision. And they still have to go to court, and you have to wait for 20 days to see if somebody goes to court. And during that period, the Alcatel period, you have to wait and see if somebody wants to challenge the award. And if they challenge the award, you have to wait a while till that challenge has been passed. They have to do that in a very short period, so it doesn't take all that long, but you do have to wait. So winning the award does not mean you have the contract. Maybe it's challenged, or maybe the contracting authority says, I don't want to have this job done at all anymore. I'm going to do something different. We'll spend the money not on a city hall but on a road, or we want to change the whole design of the city hall, for example. That's possible. So you're not sure you get the contract. All you know is you have the best, you came with the best offer. So never say that winning the offer is getting the job. That is a mistake. There are remedies. Something has been written about that in the book as well. I will leave that as well in this videotape. The modification of contracts during the contract term itself is problematic, because if you change the contract essentially, then you have a new contract and you have to approach the market again. So modification of the contract during the term is a difficult topic. You cannot just say, I had a contract for 10 floors, now I want 25 floors. That is an essential change, and you might have to approach the market again for that change.